My name is Jeff Stevens. I'm a shareholder with the law firm of Parr Brown, Salt Lake City.
How does it work?
All right, commercial general liability insurance, in its most basic form, is liability insurance for people engaged in commercial pursuits. And what that boils down to is insurance for damage to property or injury to people that are caused by your conduct. And what that insurance provides is essentially two benefits. One is it will defend you against a lawsuit. If you're sued because someone claims, when you were out washing windows, you dropped something and it dented their vehicle and they sue you for that damage, that insurance company will defend you in the lawsuit. And then if it turns out that that claim is valid, they'll pay those costs. So one of the issues that has come up, and it started quite a while ago, is the issue of when on a construction project you have defective construction that results in damage to some other part of the project. Typically, let's say they claim you put in windows that leak and the water gets in and it rots the drywall and the carpet. The question would come up, is that insured under your commercial general liability policy? Now, when that question was raised, there were two initial camps. One was, yeah, that's an accident. Okay, there was no intention to cause damage or put in faulty windows. So the first step in the analysis was the damage caused by an accident. Courts would say, sure, yes. Now the other camp that developed was, no, that's not accidental at all, because the work that was put in was intentional. People intended to put those windows in, they were intentionally made, and so whatever damage was caused was just a natural consequence of an intentional act, not an accidental act. And you had this division amongst the different decisions out there. So when these claims would arise, and typically they would arise from an owner or an end user saying, my project has been built poorly, I have damages, they sue the general contractor, and then the general contractor would tender it to his insurance company and say, look, I've got this lawsuit, defend me. Well, sometimes they would, sometimes they wouldn't, and you couldn't really predict in certain states where that was going to come out. Now, recently, over time, those camps became bigger and bigger as different states weighed in as to where they were going to come out. Now, recently, and very interestingly, many of the states who originally said, no, that's not accidental, there's no way this is covered by insurance, have begun to switch sides. And what we're seeing now is that the side that has said that this is not accidental, that damage was not accidentally caused, is shrinking very rapidly. And most courts are now solidly in the camp that says damage that was caused by construction that was improperly performed is actually the result of an accident, because it wasn't intended, it wasn't expected. And so at least for that first hurdle as to coverage, contractors can get over that. Now, it's not the end of the story, because all these insurance policies have a ton of exclusions and there are a ton of other hurdles you have to get over, but at least getting over that first hurdle is becoming easier and easier for contractors and subcontractors.